risk assessment. And we also offer AML training. We believe in excellence and continuous improvement, and for our daily interactions with our clients and other stakeholders, we have built some experience and some knowledge about which areas of AML compliance are somewhat challenging for compliance professionals and employees in the mostly in the offshore sector. So, and one of those areas clearly is the identification of source of funds and source of wealth. So, cognizant of this, we decided to put together this webinar. We are very proud to bring local expertise to you today, because we believe that local expertise is often undervalued without good reason. So our first speaker, Wasif Esak, will be setting the scene and going through some definitional issues. He will examine the common sources of funds and of wealth, and will give us an outline of the AML issues which can arise. Then we will have our second speaker, David Ombrazin, who will take us through the operational challenges often associated with identifying source of fund and source of wealth. David will guide us on how he overcomes those challenges in his everyday work. Keshal Subag, our last speaker, will give us some case studies, and he will focus on sharing practical skills which compliance professionals need to reliably identify and assess source of funds and source of wealth. We will then have some closing remarks, and if we still have some time, we will take questions from the audience. Concerning questions, we have received a lot of those from participants during the registration process. We're very thankful for that. So what we did is we put those questions to the panelists as promised, and they have incorporated responses to those questions in their presentations. However, if ever there are some questions which have been left unanswered, or if the audience feels that not enough details were given, I will invite you to please follow our Arrowheads Consultants LinkedIn page, as we will regularly be sharing posts in response to these questions there. A few words on the webcam logistics before we start. First of all, I'm sorry about that. For those of you who are in Eben, you know the thunderstorm we're having right now. A few words about the webinar logistics. First, this webinar is being recorded, and we will share the video through our LinkedIn page in a few days. Also, please make sure that you have correctly spelled your name, your display names, and written them in full, as our team will be referring to those to send out certificates of participation later on. Thank you. So moving on to our first speaker, Wasif is a very experienced compliance professional who has had a rich career in the trust corporate service provision sector. He is currently a manager for regulatory and compliance matters at Okoyan. In the past, he has also worked as jurist. He was also the compliance officer and MLRO at at Terra. We are very grateful to him for having agreed to share his knowledge with us today. So Wasif, please, the floor is yours.
Thank you, Umar. This was a pleasant introduction. Well, I welcome you all to this webinar today. I am very pleased to form part of this when Umar asked me to, because this is a very interesting topic to talk on, that is source of funds and source of wealth. Source of fund and source of wealth are crucial to the fight against money laundering, terrorism financing, since both can be good indicators that customers are involved in criminal activity. In contexts where source of fund and source of wealth do not match a customer's risk profile or established transaction activity, any company should use that information to inform their AML and CFT compliance response. And when submitting suspicious transaction reporting to the FI. I will share my screen. Just give me 1 second. Yes. Sorry for that, some technical issues. Okay. No, it's okay. So yes, we'll start by an introduction on what are the definitions of source of fund and source of wealth, and go on with other topics that might be interesting for you, like what do we do in case what types of documents that we need to use in source of fund and source of wealth, and how we carry out ongoing monitoring. We'll start by a simple definition of the source of funds first. You will note that in the handbook, I guess most of you will have seen the definition of source of fund in the handbook, and also the Wolfsberg group have provided some guidance on source of fund and source of wealth. But I will give you a more simple definition of source of fund. In simple terms, think of source of fund as a transactional driven activity. So source of fund refers to how and where the customer obtained the funds for a specific transaction or designated service you provide to the customer. For example, if I want to buy the new Samsung S22, it costs 50,000 rupees. 50,000, yeah, 50,000 rupees. I save my money monthly. I save 5,000 rupees, and till I get to the 50,000 rupees, I will be able to buy the Samsung. So my source of fund for buying this phone is my savings. This is a simple definition. Now, if we put it in the context of financial services, how to know what is the source of fund of your client? If you are in a management company, one client comes to see you to say that he wants to invest in one of your funds. You will ask him, where did you find this money to be invested in the fund? Then, how will you know if this person is lying to you, is not trying to launder his money, is to know more on his source of funds. And how will you know about his source of funds is to request some information. Some in documentations that you can use for source of fund are as follows. This is not this is a exhaustive list. There are many more that you can add to it. If you want, you can put some of your examples in the chat box, and we'll go through after the webinar or as and when required. But if you see these common sources of source of fund, you will see that they are simple. That is savings, dividends, sale of investment, gifts, lottery, insurance payouts, virtual assets. Virtual assets, I know it is a hot topic for the time being. I will come back to this later. But in simpler terms, verifying the source of funds involves confirming where those funds came from, how they were obtained by the customer, and whether this is consistent with what you expect of the customer. Verification involves more than knowing, for example, which financial institution the funds were transferred from, unless a financial institution is providing finance, such as a loan for the transaction. Checking that the customer's personal details match those on the account from where it was transferred is not sufficient. For example, if you take a savings, and in the industry of, let's say, property management, someone comes to me, comes to a property management company and say that he wants to buy a plot of land at in Eben. He has 10 million rupees. Will the savings, he says that his source of fund is from his savings. He works at a manager at a bank, for example. He has been saving this money for more than 10 years. Now, the compliance officer, what he needs to understand, he needs to know is that, does this person profile, is this person's profile in line with what he wants to buy? If you see as a compliance officer that he can derive his income from savings, then okay, you ask for more documents. You can ask for his bank statements, for example, and see if effectively he has this kind of money. If not, maybe he will take some loan, and this would be his source of funds. Now, on the other hand, there is source of wealth. I have inserted the definition of source of wealth from the handbook and Wolfsberg Group as well. This is a broad definition, but if you take the example of source of fund, which has a transactional activity behind, for the source of wealth, there's no transactional benefits as such. It is the entirety of someone's wealth. It encompasses everything that would be looked for for a source of fund, as well as historic transactions like longer term savings and any liquid assets of the individual. Such it can be car collections, virtual assets as well, precious stones, and other metals. You will see in the common sources that it's more or less the same thing that of source of fund, but there is one aspect that is important, is the non-financial aspect. Because you have to take into consideration the globality of the person's wealth, that is what he has now and what he had in the past as well. Now, with respect to AML CFT considerations on source of funds and source of wealth. First, you need to know to whom does this apply? Why do you need to apply source of funds and source of wealth, and when to apply it? First, who? It concerns everyone. May it be in someone in the financial sector, or even in other bodies or other sectors. It is regulated in the financial sector and the sectors under the FIU, but you can apply it in every sector. Now, why would you request for source of fund and source of wealth? It's simple. In our days, we are in a country that is liable to get many money launderers. So a way to be able to combat this money laundering and terrorism financing is to understand the nature of the source of fund of the person. When you know the source of where does this person who is injecting money in Mauritius, where does his money comes from, you will be able to combat money laundering. And when do you apply SOF and SOW? It's at any given point in time. You will start at onboarding stage when you are onboarding the client, but it won't stop here. At any given point in time, you may request for further information about a person's source of fund. And how do you do this? This is something that is the Bible for all compliance officers nowadays, that is risk-based approach. The risk-based approach is one of the most important factor in compliance nowadays, because with the risk-based approach, we are able to know how to treat a client and what types of documentation that you need to ask them. When you're applying a risk-based approach on a client, you will usually ask for his customer due diligence and do a risk profiling. With this risk profile, you will know if he is low risk, medium risk, or high risk. If the person is a high risk, you will automatically apply source of wealth. That is, if he comes from a high-risk jurisdiction, if he is a PEP, or there is a high money laundering and terrorism financing screening on him, or adverse media findings, then you will apply the source of wealth policy on him. That is, you have to know from where does he get he has his wealth. Also, when you are applying the source of fund and source of wealth, it is very important to document what you have requested from the client at the onboarding stage itself. This is very important because at the time of onboarding, if you have a checklist to know what was the source of fund and source of wealth of the client today, and in 2 years' time, it may not be the same. If the FSC comes to you for an inspection and ask for the documentation that you have, and you do not have anything except you have asked the client via email, it may not suffice, because it will depend on your source, on your risk-based approach. If you have requested only the source of fund of a client when it is a high-risk client, then you are doomed. So the documentation is really important. One last part on the risk profile. Once the source of fund and source of wealth due diligence has been carried out, the assessment of the customer's risk to the FI and their risk rating should reflect each of these inquiries in a coherent, consistent, and plausible manner. That is, you have to document it. It is better to document it in your risk profile itself, what you have done as part of source of fund and source of wealth. And there are some factors that can be considered as part of your CRA process that could include whether the overall net worth or wealth of the customer has been documented adequately in their profile, or whether the initial and ongoing source of fund have been documented adequately. Talking about ongoing due diligence. So ongoing due diligence would depend on your risk profile that you have set up at the onboarding stage. For example, if you have the usual methodology of most management companies or other companies here is that for low risk clients, you will do an ongoing due diligence every 3 to 5 years, depending on your policies. Medium, you will most probably do it every 2 or 3 years, but high risk remains at least every year. So how to apply ongoing due diligence to source of funds and source of wealth is that you have to maintain what you have done via the risk-based approach. If you have a high-risk clients, you do the source of fund and source of wealth every year. You reassess it. If you have a medium risk client, as per your policy, you can do it every 2 years. But it's important that you do it on an ongoing basis. Transaction monitoring as well, you have to conduct it, because it will it's one of the most detrimental part of source of fund to know that this person is not laundering money, and you do it via transaction monitoring. One important factor is avoid the checkbox approach. It is essential that judgment and reflection are applied when obtaining and trying to understand source of wealth and source of fund information. Time should be invested before reaching a conclusion on whether the information provided makes sense and is plausible. This should never be a checkbox or one size fits all. Companies should provide relevant staff with the appropriate training and guidance to support them in understanding and these requirements, in addition to monitoring and testing of the effectiveness of this important control on an ongoing basis, must be done. Last one, I will say documentation is the key. You always need to document what you have asked the client and make the most of it so that you can have it readily available. That's all for me for today.
Thank you, Wasif, for this excellent introduction. I see we've got a couple of questions. One of them, I think, pertains to operational challenges, which David will take next. But the second one about whether you can say that funds and wealth are interrelated. Maybe you could just share your thoughts on this for 1 minute. I guess it pertains to the definitional issues between source of funds and source of wealth.
Sorry, can you repeat?
So if you could just share some light on the question we received in the chat box from say, the MLRO. So can we say that source of funds and source of wealth are interrelated? So I guess needs some shedding some light on the definitions. What are the differences between the two?
Yes, they are interrelated because you have source of fund first, and you get source of wealth. Source of wealth is you can take all of source of fund and add it to the source of fund to the source of wealth. Source of wealth, it is a combination of the source of fund plus the non-financial assets that a person may have. So a source of wealth is a combination of source of fund. Exactly, it is interrelated.
Thank you, Wasif. Fortunately, we won't be taking more questions on this topic right now, but we will have some time at the end to take questions. We have to move on to keep to the time. So our next speaker, David, is currently an Associate Director for Risk and Compliance with the JTC Group. He's also a tutor for the Training Institute. David is exposed to the challenges posed by an effective implementation of source of funds and source of wealth policies, procedures, and controls on a daily basis. So we thank him very much for having agreed to share his experience with us and giving us his take on how he tackles the operational challenges which compliance professionals usually face. So over to you, David.
Thank you, Umar. Good afternoon, everyone. Good afternoon and good morning, depending on where you are attending. I am aware that some of you are attending from other countries, so I'm very glad to see. I'm very pleased to have been approached to form part of this panel today to discuss about such a hot topic as source of fund and source of wealth. Wasif and Umar have well explained the importance of source of fund and source of wealth today. And after going through all the remediation that had to be done by the different operators, so merchants could be removed from the FATF grey list and from the EU blacklist, I can say today that a proper documentation, a proper approach in terms of controls to source of fund and source of wealth is actually quintessential to ensuring that Mauritius remains off these two lists. And with the prevailing situation of COVID and unfortunately whatever is happening nowadays with Ukraine and Russia, we cannot afford to get back on those lists. Economically speaking, in terms of competitiveness, we must ensure that all our controls remain at a certain level so that we don't fall back onto these lists. However, all this is very nice. It's very good to say all this, and Wasif has gone over some of the theoretical aspects. But in practice, as my learned compliance professionals will know, it's not as easy. As a compliance professional, but also I'm talking also to the client-facing teams. It's not that easy to ascertain source of fund and source of wealth on a day-to-day basis, depending on the type of clients that we are dealing with. So I will try today to share with you some of my experience and some of the different challenges that my colleagues in the industry and myself have faced during inspections or on our day-to-day in our day-to-day work. So I'm going to share my slides with you. Okay. So first of all, there's something very important that Wasif said. Wasif said that if a compliance officer is happy with information, he can ask for more. It is often the case and often a perceived thing that source of fund and source of wealth concerns compliance. Everything that has to do with CDD concerns compliance. But who owns the risk? Who is the first point of contact with the client? And God forbid, we compliance professionals are often asked not to talk to clients. So who really owns the risk? Risk is a concern for everyone in the organization, for everyone at every level. But it is important there to remember that we have three lines of defense. We have the first line of defense, I mean the client-facing team, a second line of defense, the compliance officer, and the third line of defense, which is the independent audit function. But we won't dwell on the independent auditors for now. Sorry, just 1 second. There you go. So when the client officers deal with customers, they are the first persons who will actually ask the clients for their source of fund and source of wealth, not only evidence, but information. So it is their responsibility somehow to ensure that when communicating with the clients from the onset, the clients or prospective clients are provided with a correct rationale for why we are asking this information. And also, they are also communicated the correct documents. One of the main tools that you have when asking for source of fund and source of wealth is through your documentation. The documentation that you send to your prospective clients, okay, for example, your onboarding form. You need to be able to review your onboarding forms to ensure that when these forms go to the client actually, by reading the form, gets examples of, okay, you're asking me for my source of fund and my source of wealth. What is source of fund and what source of wealth? Is it explained in your form? Do you have some examples in your form? By doing this little adjustment to your controls and to your documentation, you're already mitigating the risk of your clients not understanding what you're requiring from them, and thus mitigating the risk of further frustration from the clients when you will go back to him or her and ask for additional documents. So one of the issues that we face sometimes, like the client administrator or the client-facing team or the person doing the marketing himself or herself do not have a clear picture of what is actually source of fun and source of wealth. Or maybe sometimes you're scared towards the client because we need to keep this relationship with the client. So that's why sometimes we use compliance as a second line of defense, whereby compliance is asking for this and that. But it is important to avoid such situations, to train your first line of defense correctly. Your first line of defense need to understand what is source of fun and what is source of wealth when they ask the client for such information. By training your staff, by reviewing your documentation, ensuring that your onboarding documentation is clear, provides examples, you're already ensuring that the probability that the client will not provide you with correct information or that the client will not understand what you're asking is reduced. So my first advice for today would be check your documentation, ensure proper training of your staff, to at least those dealing with the clients to ask the documentation. So it might be marketing, business development, client facing, director level, whoever is dealing with clients. Then sometimes it's not only your first line of defense who's involved. You have intermediaries. Those of you who have fund companies, fund entities under your administration or who are working for a fund, you know that sometimes you have fund promoters or relationship persons involved. These are the persons who will actually go and seek the clients for a fund. Those are the persons who will act as a middle person between you, the management company, between you, the fund, and the investors. These persons, unfortunately, have a marketing mindset. Their job, and it's not their fault, their job is to bring clients, to bring investors, okay, to create wealth, to ensure that we get the maximum of investors in the fund, to make the fund successful. We can't blame them for that. However, by default, these persons become client pleasers. They do not want to put themselves in such a situation where they are uncomfortable or where they are having frictions with investors. So these persons, what do you do then to mitigate these risks when you rely on such persons? You need to check, are your third-party introducers or your intermediaries applying the same standard that you would have applied? Have you made them aware of what are the standards which are expected in Mauritius? You know, we are a fund, we are licensed by the FSC, this is what the guidelines say, this is what the FIAMLA says, the regulation says. So ensure that when you go and seek investors, that you make them aware from the onset, we need this, we need that. Some issues with CDD documents, for example, are very typical depending on which jurisdiction you're dealing with. For example, when you deal with investors from a certain jurisdiction, you will realize that some of them, if they send you their CDD documents and will put like self-attested, which we can't accept. So then again, I go back to when the subscription forms and the CDD documents come back to you, and God forbid you get them original certified, at first. So the documents come to your office physically. When you look at the documents, self-attested by Mr. X or Mrs. Y, what do you do then? Documents go from client-facing, come to compliance. Can you please check and vet the documents? By the time you vet the documents, too late. The client has already sent the documents. Do you go back to the client and to the fund promoter? You know, the client has sent the wrong documents. The client has not followed the certification guidelines. Have you checked the subscription agreement of a fund? Have you checked if they have in the subscription agreement guidelines on how to certify your documents, on how to put the wording of certification? Have you done your in-house checks before sending the documents to the clients? How do you reconcile the risk of not only dealing with investors, but dealing with investors through a fund promoter who might not be trained? Maybe not just, you can't just blame the person. Maybe this person has not been given the correct training by the fund officials or by the compliance officer, by the MLO, to ensure that this person knows what he or she is asking. So in practice, dealing with intermediaries has proven to be quite difficult sometimes. But I can assure you that with proper communication and with proper assistance to these persons, you can actually reach a certain level whereby the person understands, and where you make the person understand as well that you can't compromise below a certain standard. I know that we received a question, for example, what do you do if your source of wealth and source of fund documentation or evidence does not fit your standard? My advice would be, if I'm talking to the person who sent the question and to everyone, but if you have, like you said, a standard, you have set a standard which should normally be in line with the regulations, the laws, the national risk assessment, and your business risk assessment. So whatever is your minimum level, I would say if something does not even meet your level, then you don't accept it. If something, because if you've set the level, well, your standard is meant to be the minimum, the de minimis. So if you can't accept, if something doesn't reach your de minimis level of risk, which is accepted to you, which puts you in a, between the commas, comfort zone, why would you go below that and accept something which you know you can't handle as per your risk appetite? So that would be my answer to that participant who asked that question. If you ever want to accept such things, if you see, for example, that out of 10 investors, 8 are sending things in such a way, and your risk assessment doesn't allow you to take that, maybe then you need to reassess your risk assessment. Will the board be comfortable with reducing your business risk assessment? Have it documented, bring it to the board, amend your risk assessment, have the board ratify or approve same. Documentation, documentation, and documentation. Okay. Difficult clients. Some clients are difficult from the onset. Okay. Some clients have, unfortunately, some clients are the type of person who say, look, I have the money, I don't have time, I want to invest in your fund. So either you take my money or I go somewhere else. How do you deal with such clients? Some clients become difficult and frustrated with time. Why? Because when I asked you the first time about what do you need from me, why didn't you ask me to tell me at that time? You need to provide me with your bank statement for the past 3 months. You need to have it certified by a lawyer, etc. Why do you wait for me to send you the documents for now? I should get back to my lawyer or to my tax accountant to certify the documents. Why? Okay, so all these things create frustration in clients. You need to get things right the first time, or at least aim for it. This will avoid that in the long run, your clients become tired, frustrated, they feel insulted sometimes. There's nothing much we can do about it. I've met some clients who feel very insulted, and funny enough, some promoters which felt insulted in lieu of the clients, like you're asking for the source of wealth and source of fund of Mr. X. Do you know who Mr. X is? Do you know that Mr. X family can actually buy your whole fund? These are things, and I in these scenarios, I'm happy not to be client-facing. For my colleagues who are client-facing, I don't know how you do it, but these are real situations. And the client-facing team have a very difficult role to play, because at the same time, they are the face of the company. They need to give information to the clients. What CDD do you need? What information? Why we need this information? Goes back to the training. You need to have your staff trained. Then they are the recipient of not only documents and information, but the recipients of frustration. Then they get back to you. Compliance, this is what we have. This is what the client says. Is that okay? No, we need to have this and that in that order. Then the client-facing team will have to reconcile the business needs and the compliance needs. Where do we meet? Is there a middle ground where we can meet? Then with experience and with a good understanding of your risk and a good understanding of your clients, you can always, well, not always, but most of the time, you can actually compromise on some things. Again, like I said, don't go below your standard, but you can compromise on something. You can mitigate some of the aspects of the risk. And you can say, okay, we will accept this for now. But for instance, Wasif talked about reviews. At the time of review, your client will need to send me this document in such and such format. the source of fund that your client has provided in the first instance, for example. Okay, I understand his profile, etc. He's putting in a minimum amount of money, let's say £100 for a fund, for a trust. But when he will input the next sum into the trust asset, we will need this documentation. And if he does not provide same, then we will trigger, we will send a communication, we'll explain to him, we told him that we told you last time we needed this and that in such order and in such status, at such status. If he can't comply with it, then the business will need to take a decision. I see another participant has asked a question. What does compliance do when source of funds, source of wealth is not enough? Compliance is not responsible for deciding if you're taking a client or not. We have the policies and procedures, or at least you should have policies and procedures. You should have your risk guidelines, and you should have your BRA and your CRA, your client risk assessment. This is what compliance does. Compliance ensures that we comply with the minimum risks, minimum guidelines, and minimum laws. We advise client-facing team and the board on compliance and risk matters. We must stress on the risk element, because risk is dynamic. Risk is not something which is here to stay as it is today forever. It is dynamic. So compliance cannot, unless something falls outside, like I've said, of your risk appetite. For example, if you have a list of businesses that you really can't take and this has been approved by the board, unless something falls within that list, you can't tell, we can't take that client. You can advise the board, I would not take that client because of X, Y, Z. If the board maintains and wants to keep that client, because obviously, like you've said, this participant said, you want to keep management happy, have the board in a file note, or if you have something called a senior management approval form, have the board document the rationale why they want to keep that client, and ensure that as a compliance officer, as MLO, as compliance professionals, you put your rationale as well on that form. You put on that form that you have advised the board otherwise, and whatever reason why you have advised the board otherwise, and then have it signed by the board, sign it yourself and document it. Make sure that this is on file. Okay, but compliance cannot say every time that cannot decide every time if whether or not we need to take a client, we need to onboard a client. This is not a market. Compliance can't be involved in marketing or in business onboarding at that level. At least in most companies, but that will be the way things work. So you need to keep the business happy. It's true. Without clients, there's no money, there's no profit, there's no salary, even for compliance professionals. So, like I said, to avoid all these situations, get things first the right time, get things right the first time, ensure that a proper communication challenge is established with the clients or with the intermediaries and to get the good information the first time. And we explain why we need this information. It is in the interest of the fund and the interest of the investors as well. We don't want you to have a bad profiling or to appear to be someone you're not in terms of financial crimes and someone who's trying to evade proper documentation. So it is also in your interest, in the interest of the clients, to provide the good documents. And yes, we need to strike a balance, but that's a teamwork between the compliance, the board, and the client-facing team to strike the balance, but we don't lose business, but we also ensure that the risk level is maintained. We have the issue of lack of trust. As much as source of fund and source of wealth is a regulatory and legal requirement, people are very private about their earnings. People don't like to share their salaries, their pay slips. People don't like to share their bank statements because you won't only see their salaries in the bank statement, you will also see other things such as, private things in which they are investing. And this is maybe not something that they want to share with you, okay? So lack of trust is based on the document that we provide, and also some persons do not trust certain jurisdictions. For example, you might have a lack of trust in the merchant system. And it is up to you to show them that we have proper systems in place and proper controls in place. over documentation or under documentation. You need to apply a risk-based approach. In some situations, we ask too many things to the client, and this again leads back to frustration. So we need to strike a balance on what to ask the client, depending on his profile and the risk assigned to the latter. Is the client a PEP? If the client is a PEP, you have to enforce enhanced due diligence. So then, yes, you need to document more. But if you do a simplified due diligence, you need to look at less. Sometimes, unfortunately, we also have situations where there is no documentation. A client, for example, has inherited his wealth 30 years ago, and he can't prove it. I mean, for him, it's like 40 years ago, his family passed away, he inherited everything. So how do we ask for evidence of that? So in some situations, you will have no documentation, okay, or lack of documentation. Then it's up to you to build up your case and also do your independent research on the net, whatever resources you might have, to at least get a profile of a client. If someone, for example, is a high net worth individual, it is highly probable that you will have information on that person. Your independent research is very important because you need to tally the information that the client has given you and the information that you get independently. Complex trails of funds. In some situations, it is very hard to know where a fund is coming. I'll give you an example. You have a miner who is actually holding shares in a fund. Can happen. Obviously, the miner doesn't have any earnings in terms of salary. So when you ask the question, where does the money come from? From the mother. Okay, fair enough. When you ask about the mother is a homemaker. How does a homemaker get money? From my parents. All right. What do your parents do? My parents are dead, but I inherited everything 10 years or 15 years ago. My dad was a PEP. How do you reconcile your risk in such situation? Can you ask the CDD documents of a mother? Can you ask for a proof of inheritance which dates 10, 15, 20 years ago? Is the fact that the grandparents were PEPs really relevant? And even if it is relevant, in practice, can you apply the enhanced due diligence? So these are the challenges that we'll have concerning trails. Another example, I'll go on it quickly. You get loans. One entity puts money in your business. You ask him what is your source of fund? Loan from where? From a third party. You can have a financial statement of your direct client. Can you ask for a financial statement of the one who has given a loan to that client? No, but you can obviously ask for a loan agreement. That's something that you can put on your files. But how far can you go? How far does even data protection law allow you to go? Because you're asking for a financial statement of a third party, which does not have any relationship with you. Complex and conflicting narratives. Sometimes your client themselves provide you with wrong information. They tell you, I am a director of ABC Limited. So when you build up the case of that client, you go on LinkedIn, you go everywhere, he does not appear as a board of directors. When you talk to the client, he tells you that I'm saying director, but I'm actually director of, it's called director in the company, but he's not on the board. So the information do not tally. So when you do your independent research to try to make sense of a source of fund and source of wealth of that person, the information that your client has provided does not tally. Goes back to my first point. Ensure that your clients provide accurate information, that they understand why we are asking this and what we are asking. What if the profile of a client does not fit with whatever you get online? Someone just started working and he tells you, I'm investing £100,000. Okay, where do you get your money from? From my employment. He sends you his CV. He just started working last month. Does he earn £100,000 as salary? And would he invest his first salary as a whole in your fund? Okay, so these are the kind of questions you have to ask yourself. Even if you get a bank statement, it's not enough. Sometimes we get bank statement of proof of address and the bank statement has been opened the week before. So possibly, most probably, the funds will be coming from another bank statement. So another advice would be when you ask for bank statements and you ask for a bank statement from where the source of the funds will come. Because at least you can see, for example, if someone tells you my source of funds for my salaries, you can see in HSBC, for example, salaries coming in every month and then money getting out of that account. The last point would be, for my friends from the FSC, regulators' expectations. Obviously, the regulator will have expectations, just like you as a financial institution will have expectations. The expectation of a real regulator, unfortunately, does not always match what happens in practice, the reality of things. For instance, let me give you an example. You have a fund. Someone has invested in the fund 7 years ago. When that person invested at the time, source of fund and source of wealth was not as stringent and was not as documented as it is today. That person has not put one dime since then, not one dime in your fund. Can you go back to that client during an inspection? The FSC comes and say, you don't have source of fund documentation on that person. He's a PEP. Yes, I know he's a PEP. And we can see online that he's worked at, for example, JP Morgan or Goldman Sachs for, I don't know, 30 years. I can assume that someone who's been chairperson or CEO at JP Morgan can invest £100,000 from his accumulated savings. But can you go back to that person and tell him, oh, 7 years ago, you invested £100,000. Can we have a documented source of fund on that? So you need then to explain to the regulator as well, what is the situation? That person is not working anymore. That person does not receive any income except for his pension, maybe. And that sum has been invested 7 years ago. And nothing else has been invested yet. However, should the person invest again, we will ensure that we will then request for proper documentation of source of fund. Put that on file, document that, and generally speaking, the FSC, the regulators in general, will be satisfied with the mitigating control that you're putting in place, because they understand that some things can't be done. They can't be done because in practice it's too late, or there's no rationale for doing it now. But you need to have mitigating controls in place in the event that things happen later on. You will ensure that you request the proper documentation. So that would be all for me. Thank you very much.
Thank you, David. And I appreciate the effort to put all this information into such a concise presentation. I'm sure the audience will understand that. This could indeed go on for much longer if we had to give all the details, but I think David did a great job at keeping this as tight as possible. So next on is Keshal Subag. Keshal is currently the Group Compliance Manager for a large multinational with a presence in more than 30 countries. He has worked with some of the big names in the trust and corporate service provision sector, and he has also worked for the FSC. So he's also a part-time lecturer at the University of Mauritius, and today he will guide us with some case studies which he designed to allow us to grasp the more practical aspects of the identification of source of funds and source of wealth. So please, Keshal, over to you.
Yeah. So good morning, everyone. I hope you have had quite a very good exposure on what is source of fund, what is source of wealth. I think that we had a question on the chat box, and Wasif handled it. And yes, if you need further clarification on what has been provided to you as a reply, so feel free. We will provide you with as much as details that we can. And but just on that note, before coming to the introduction part of this last section that I'm going to cover, which I think would be very, very interesting, because you will acknowledge in the first part what we have done is to introduce source of fund and source of wealth, and we have concluded that, and we agree to this that this is a legal obligation. When we talk about source of fund, source of wealth, provision has been made in our governing law, AML safety law, precisely the FIAMLA, that we as financial institutions and also non-financial institutions, which nowadays include real estate operators and NBFIs, everyone. So we are concerned. And being a legal obligation, we have no choice. We have no choice to comply. That's a fact. That's a fact. But at the same time, the second part that David actually covered was to share with you, and it's not that David has shared this with you, it's you yourself, based on the question that you have said to us and the comments that we are having in the chat box. So it's definitely that being a legal obligation, we have a lot of operational challenges. Okay, so as an introduction to this part that I will be covering, is my objective is to bring in some insights based on experience, based on cases that I've worked on, and to try to find out, to propose at the minimum some quick wins solutions, some quick solutions that you can consider, And for me, being in the industry for quite a number of years and having a network of compliance professionals with whom we talk, we share our knowledge. There is a compliance community, so we share our opinion on different topics, different subjects, with the aim of finding an optimal solution. You know, we as compliance officers, our roles are defined within the law. We need to abide by the law. We have certain duties and responsibilities as prescribed in the FIAMLA and the regulations. So we need to go by this. And at the end of the day, like David mentioned it, so we are an employee within an organization. So we are mandated, the law sets out our duties and responsibilities. And while it is also a fact that we are employee within an organization, so we have to ensure that whatever is being done, whatever we are recommending in terms of compliance is practical. This is a word. We have to be practical. When we say source of fund and source of wealth, the assessment of source of fund and source of wealth, we said we need qualifying documents for that. And here itself, we have a big problem. David mentioned it. We have difficult clients. We have different scenarios that prevent us from having those documentation. So what we do? So this is why this part, we have the title or that we have brainstormed around this. So we come to you with a case management. Okay, so we know the problem. We know that what we have to do. This is a legal obligation. We know that this is of concern. Operationally, there are operational challenges. So what we do? So we come to you with something that we call. I hope that my screen is being shared with you. Yeah. So I'll just begin the. Give me a moment, I'll just try to share this with you. Yeah, so it's good, guys. So here we go. So what we have for you is a practical case management again, I'm telling you that our objective behind this is to bring in some insights and to provide you some practical solutions. It's often said that compliance causes in terms of commercial operation. So we are here that the role of compliance is to ensure that we do things in a proper way. So this is it. My friend David actually talked about this. So we are part of the line of defense. And as I told you, we work for the organization. We have our duties and responsibilities prescribed under the law. And what we do, we need to do to ensure that the risk management, risk mitigation plan that we are expected to have as per the regulatory provision. So these are adapted to our nature of business. This is one thing. Core part, like you will see when I shall go through the slides. You will see that much more emphasis in this part has been put on compliance analysis. Okay, compliance analysis, because when we say compliance, we say KYC, just to touch base, there was a question on the chat box concerning data protection versus AML CFT. So I will be the direct answer to this one is that AML CFT provides that we need to conduct proper due diligence, while data protection tells you that you need to protect data, you need to protect the preserve the sensitivity, confidentiality aspect have to be taken into account. But in the same piece of legislation, the Data Protection Act, there is a mention about lawful processing. So to answer this question right away, so when we talk about that as part of KYC, we request document. So this is a lawful processing. We are required under the law to request those documents and to get hold of the documents for what? Not just to have it on our records. And this is what we are going to explore in this session, the compliance analysis part. So what do we do with those documents? Okay. And we have termed it like this. So how do we present our case? Because we have a case to defend. The regulatory authorities will come to us. The management will question us. So why are you saying this, that this particular client cannot be accepted? Why? The regulatory authority will come to us and say that, yes, you have done X, Y, Z in terms of assessment. So why haven't you done, why don't you have an updated document highlighted the fact that yes.
We, I mean, your mic went off for like 15 seconds. So if you could make that point again.
Okay. Okay. So it's okay. Can we carry on?
Yes. Now we're hearing you.
Okay. Okay. Good. So to start with, I hope everyone it's okay. So we can carry on. Okay. So I'll start with this one. This quote said by a genius, and what the purpose of having this here is to get the morale behind it. Good to get the morale behind it, because when we say compliance, and I'm relating it to effective case management. So what is important for us to know, the compliance community, to get to know what is the actual problem. And my colleagues before, Wasif and David, explained quite well in terms of what is expected and what are the challenges. So we need to know what to do next. What is the solution? So this is why, going through the slides, so we are going to explore some inherent factors that cause us to be non-compliant, if I can put it like this. Can lead to non-compliance in terms of source of fund. I'm saying lead to non-compliance because of what in comparison to what is expected. The regulatory authorities expect us to have documentation on file. Yes, but we do have these three inherent factors that we have termed inherent factors. The reluctance factor, because of the sensitive nature of those documents. We have the secrecy laws, international laws, okay, that prevents international authorities, international operators to share information on their client. So this is the fact again, because the same way that they are licensed and regulated, we also licensed and regulated, and we know how it works. If you go outside the scope of the law, so they will be in breach of their own piece of legislation at the end. So this is an inherent factor. We don't have a grip on that. We don't control that. This is an inherent factor that we have to bear. Reluctance, secrecy laws, and you have the concept of reliance and trust. Like we have put it there. It is convenient that we can rely that in terms of source of fund, the bank provides me with the bank reference letter telling me that as per the template of the commission, the statute, name of the person, shared business relationship for the last 2 years, with the mention that satisfactory, that the business conduct has been satisfactory as per the bank. So do we trust it? We have no choice. We have to, because this is part of in terms of, someone mentioned in terms of checklist, in terms of qualifying documents, this forms part of one of the qualifying documents that the regulatory authority actually expect to see. bank reference, bank statements that are being shared. So what do we do with those bank statements? David pointed out that bank statements have to be assessed. And this is what I'm putting forward, again, the idea of compliance analysis. We need to know the inflows and outflows. We need to question. And then at the end of this session, when we are going to summarize in terms of the proposed solutions, you will see that we have a template for you, actually, in terms of how do you document your risk assessment. Okay, so to end up on this one, because my colleagues before, the two panelists were quite clear, we went in detail about the definition and the operational factors. So what I have here is just a summary. That is the reluctance factor, the secrecy law, and the reliance and trust. These are the inherent factors. We can't do otherwise. Okay, the slides will be shared with you, and you can have these for your readings, because under the secrecy section, secrecy laws, you are aware about it, because whenever there is a link, you have the L'Express, you have in the local press something mentioned, offshore, there is something related to a company, to a transaction. So the regulatory authorities just send you a beautiful letter asking you for, yes, to provide details, what has been the source of fund, what has been done, and so on. You see, so in these particular cases, why have it here just for reference purposes is just because we said that secrecy laws as it applicable in the foreign jurisdiction. So this is a causing factor that blocks us at the level of Mauritius, us as compliance person and our frontliners in terms of AML CFT controls, because they are also frontliners. Huh? We don't have only frontliners for the COVID part, so we do have frontliners to help us in ensuring the effective enforcement, implementation, and enforcement of the money laundering, anti-money laundering, and countering of terrorism financing factors that we have. Okay, so this one will be shared just to have it in your mind that, yes, what do we mean by secrecy law? So this is what it is. In terms of the Swiss secrets recently, which concern over $8 billion in assets. So does it mean that Credit Suisse, who was a bank concerned in this particular transaction, does it mean that Credit Suisse is in breach of the AML CFT law? Because why? Because such information has not been disclosed. So you see, so this is what I mean in terms of secrecy laws. There are jurisdictions that prevent them to share information, and at our end we have the law. We are expected to have qualifying documents, but this is it, the inherent factor that prevents us from having it. So what do we do? What do we do? So this is what we have for you in terms of our next slides, and we have summarized it. We have regrouped it in around three test cases. One is for the investment management company, second one will be leasing, and third one would be treasury management and investment dealers. I hope this will be fine with you, because this is again based on the question that you have set. And we have the profile of the people who have sent us those queries. So thank you very much, guys, because this has been very, very helpful, because, in terms of documentation, we could have just come here and present something, talk about a topic, but it is based on your queries that you have sent to us. You have the question that you have put to us. So this has enabled us to sort of customize some slides for you. Okay, which we definitely would be, we hope that it would be beneficial for you in terms of your compliance operation. Okay. So case discussion. Firstly, this is what I have here is a quick snapshot. Some keywords, some key aspects, subject matters that I have taken up from the list of queries that we have received. There have been a lot. There have been duplication as well, yes. But what we can retrieve from those list of questions is principally, yes, the many people have asked the question that is in terms of qualifying documentation, level of substantiation. So what are the documents that we need? I believe that Wasif has been quite clear about it. And David mentioned that in terms of operation channels having it. So I will be tackling this in terms of these 3 test cases that I have for you. Other issues that we had, and I want to explore that, is the concept of handing of PEPs and high net worth individuals. Okay, because let's take the case of high net worth individuals. The definition itself, I don't know who had it. It clearly explains high net worth individual. So I know that the law requires me to request for qualifying documents. And I know that my business model has been defined in such a way that I have dealing with high net worth individuals. So does that mean, will the regulatory authority expect that I'm going to request these high net worth people his bank statements for the last 6 months? So it's not practical. It's not practical. I'm not saying that it's not good, but it's not practical. It's not practical. So in such cases, what do we do? So again, we bring into our title for this part. So we build up our case. We build up our case by getting hold of all those information that we can retrieve here and there, directly related, indirectly related, and then the solution that we propose is to have everything documented, to have it assessed, and to have a level of assurance to be put forward by the compliance person, and which has ultimately to be approved by the acceptance committee as defined in your BORA. Okay, so I will come to that afterwards, but here it's just a quick snapshot about the different topics that we are going to touch base in the different test cases. And again, I have the last one that you will see below, the omnibus account. Omnibus account. So this will there will be a test case that under the investment management company. So we are going to touch base on that. So what do? We have a lot of international market players, so who are in the market. So what do we do in such cases? Okay. So I hope for us that now it's okay. Qualifying documents. So this I have done. Degree of scrutiny. This is also very, very important. Degree of scrutiny. So for degree of scrutiny, I'm going to refer to the next. This is a pictorial representation again, just not to make it too boring. So degree of scrutiny, I'm going to relate it to the red flag. You know, we talk much about red flag, and it is often associated to suspicious transaction reporting. But here, it is being linked to the assessment of source of fund. So you tend to see how. So here it is. I believe that in the audience we have many people who are from the compliance background, and yes, source of fund, source of wealth already defined. So you have, as per the law, you should be performing profiling on your client. Based on your profiling that you are expected to do, you are required to identify that person. Firstly, he has to be a natural person. If you are dealing with a corporate, you have to identify the ultimate beneficial owner, because this is where the funds come from. And if you come to the conclusion that that guy is eligible as per his background that you have done, the screening that you have done, that guy is eligible as per the documentation provided, eligible for investment $50,000. Okay, $50,000. This is what you expect based on your assessment of the profile. But as per the current transaction, he is doing $1 million. Isn't it a red flag? Should be. But a red flag requiring what? Requiring further assessment. Requiring further assessment in terms of source of fund. So, because it may happen that over the years, it can be after 2 years, maybe he have had other sources of income, which is not reflecting in your records. So you have to ask the question. Okay, you have to ask the question. It's not that we are not trusting the client. We need to ask the question. And as part of the client risk assessment policies that you are having, so these have to be documented properly, that in terms of red flag, what are the instances that will trigger this going for asking for additional in terms of question, asking for additional documentation. And this is where the acceptance committee have a big role to play. Very, very important role over there. because it may happen that we share a long-term relationship with the client. David mentioned in terms of someone investing. There is a question as well in the chat box. Someone investing, an investor having an investment holding company. Over the years, the investment was done 10 years back. Today the investment company has been realizing gains from its investment in different sectors, whatsoever sectors, and now we have an inspection and there's a request for source of fund. So you see, in this particular case, this particular scenario is not, if I can put it like this, is not applicable. Okay, because the fund were invested 10 years back, and today, as of today, it is not topical. But it is also very important as part of your CRA to conduct proper checks on the profile of the person, because the question that has been set in the chat box is two perspectives. I have taken it into two perspectives. So the first point is to have this assessment, because investment holding 10 years back and assessment being done now. So do we ask him to provide source of fund documentation in respect to that investment? Not applicable as such, but his profile has to be continuously assessed, screened in respect of other risk factors that we have. And this is why you will see in our proposal part, we are recommending a practical business risk assessment with client risk assessment procedures, relative client risk assessment procedures to be associated to this process, whereby the weightage, specific weightage relative to the business activity will have to be assigned to those risk assessment factors. Okay, I come to that afterwards, but let's just take the case one, investment management company, where there have been a lot of questions about handling of high net worth individuals, and I touched base just before. The term itself, high net worth individuals. So what do we do? So we have those information available on the net. Someone can tell me that yes, the regulatory authority doesn't rely on publicly available information. What is the source? Okay, what is the source? So what we propose in terms of the risk assessment to be done in respect to those profiles. So we have to review the biography and milestone achieved by those persons, because I can't come and say that I am a high net worth individual, guys. So if I am claiming to be a high net worth individual, it means that there is something behind. Okay, there is something behind. So in terms of those people, the profiles, there are a number of reports, because when we're talking about investment holding, we talk about the global business. So there are many people who are in the list, the Forbes list and other reliable sources, whereby we can get information about those guys. And you go on Google is our friend, and on Google you can have a lot of information as well. So for high net worth individuals, maybe if I can reply to your concern concerning high net worth, source of fund of high net worth individuals. So this is what we propose. Explore the public domain. Okay, and afterwards, it's not just go on Google, type the name and PDF the paper and have it on your records. I'm not telling you this. I'm telling you that to get access to those information and use the information to build up your case. You say that this has been done, and afterwards, I'm going to share with you the template that we are proposing to you in terms of how do you build up your case. So you will see afterwards what we mean by that. Okay, but for now, the case one, investment management company, high net worth individuals, this is what we have for you. Relevant statistic from annual report from own entities. Mostly it is mostly the case. Most often it is like this. They own big companies, multinationals. So this is what we propose. In terms of handling of PEP, this is a debate. Maybe we can have a webinar specifically on handling of PEPs. So you know, in the handbook, as per FATF as well, there are 3 types of PEP that have been identified in the handbook: the local one, the foreign one, the international one. But each and every one, all the 3 are supposedly to be rated as high risk. Okay, we are fine with it. Why? Because they have been previously they have been involved in the political arena, and it is suspected that they might have gain, have proceeds from the government of bribery and corruption practices. Okay, therefore for here, what we can say, we can't do as well, because this is what the regulatory authority expects us to do. But if we document our assessment by saying that the PEP is a foreign PEP, yes, or is a local one, or is an international one, and in terms of its exposure in respect to the client entities that we are screening, we can definitely come out with a statement saying that yes, this is the case, this is what we are doing, and on AML and on MLTF perspective, so we don't view that there is actually something that we should be cautious of. Okay, and in terms of documentation that we can access on those PEPs, for the local one, you just go on the National Assembly website, and you can have the background of those ministers, of those people sitting over there. And Mauritius is a small island, and each and everybody is related to each and everyone. So this is a trend why each and everyone can be a PEP at the end of the day. So in terms of information that we can gather on this type of people, these profiles, so this is what we have. Different sources. That is, our point is concerning high net worth individual and handling of PEPs. Explore the public domain and build up your case. Okay, and build up your case. If you have any further questions in respect to this particular case, we should be glad to get it through our LinkedIn page, through Arrowheads. Umar will be communicating with you in respect to this at the end of this webinar. But we have time. I'm just trying to be within the we have for this session. So we will be glad to attend any sort of queries that you have, further clarification that you will need on this particular case. Second one is a leasing company. Who is a leasing? Given the nature, because we talk about nature of activity. This is, for me as a compliance person, this has to be the main factors that I have to take into account for me to develop my BRA. David mentioned in his expose that we need to set a standard. Yes, it has to be as per the law. Yes, I don't say that we should not conduct KYC. We don't need document, but it has to be adapted to the nature of business. What if we set a high standard in this particular line of business, or in the other one that we are going to look afterwards? Okay, because as per the nature of business, because that person comes to the leasing company for a financing. It comes for financial assistance. This is what he comes to you. This is why he comes to you. But in terms of the business model of a leasing company, based on my own experience, so the main factor is within a leasing company is the credit assessment that has to be done. And as part of the credit assessment, there is a threshold, there is an amount that is agreed to be approved. Okay, so based on the amount, based on the profile, and this is based on the profile of the client. This is why we request them to provide the MCI, the consent to go for the MCIB report and to run report and everything. Okay, so for the leasing company, I will stress on red flags. The pictorial representation that I had before, expectation versus the actual case. So this should be a triggering factor. Okay, and concerning the leasing company, there are different factors that need to be taken into account. Let's say in terms of the liquidity position, which is inferior to the lease amount. So this is a red flag that you will need to go for the assessment on that. If the deposit amount being transferred to the leasing company, the compliance officer of the leasing company will have a sort of reliance that this comes from the bank. So there's less implication about money laundering and terrorism financing, sort of. Okay, so this is why I have it there. What we want to conclude on this particular case is that our BRA has to be adapted to the nature of business, and this is a standard that we have to set. Okay, and by doing so, the point that David had in terms of over documentation or under documentation, we should be able to avoid this case. Okay, we should be able to avoid this case, and this is why much more stress is being put on this in terms of compliance analysis. Go look for red flags. Know what your business requires you to do. What is your business model? Okay, and based on your business model, you evaluate your risk exposure, and evaluated, having your risk evaluated, risk exposure evaluated, you are better placed to define some controls. And having defined your controls adapted to your line of business, you are able to conduct an effective client risk assessment. Okay, and then whenever comes can be the management, can be the board of directors, can be the regulatory authorities. So you are able to do what? You are able to present your case. There can be some cases that the regulatory authority want you to do this, but it would not be a non-compliance. It will definitely be a recommended action. The way that you have done it, so you improve further on that. Okay, but you are able to present your case by saying that yes, this is what I wanted to do. This is what is my business model, and this is what I have done. Okay. Just very quickly, in terms of the leasing company, you have, in terms of cash dealing, 500,000 as per the law, but many local operators have this in terms of 3,000 rupees. Sorry, 300,000 rupees. So in terms of the cases at the leasing company for the deposit, so it is often the case. Where have you received the money for deposit? The question is asked. And they often ask for unregistered sale deal. The sale deal. I have a car. I own a car previously. So I've sold the car. The client comes and says, I sold the car, and this is the money that I'm coming to put it over there as deposit. As deposit. Okay. So this has to be assessed. So I have it here as a question, and this has to be tackled, because I put it under the section red flags. So these are the instances that will require you, that will require the compliance officer of those companies to ask questions. Okay, to ask questions, specific questions, and then to do what? To document his assessment, his findings, put on his assurance level based on what he has noted, and then conclude with a recommendation to the acceptance committee to go further with the client or not. Okay. Third and last one is concerning brokerage and treasury management. So here I will be very quick on these particular activities, operation, because these are regulated activities, guys, and you can't do otherwise. And here, in terms of the client profile, we believe that this is critical. It is critical, and the dealing that we have, brokerage company and treasury management, they are individual for the brokerage side, but for the treasury management, it's principally regulated and non-regulated companies. So in terms of profiling, whatever applies as KYC is there. And in terms of source of funds specifically, so what needs to be done? What needs to be done as a solution? So we recommend a reconciliation of the transaction instead of going to ask the client, just give me your bank statement, give me your in terms of cash flows and everything. So what do you hold? You hold those information, and what we suggest that you conduct a reconciliation reasonably on a weekly basis for the brokerage sector. You conduct this reconciliation, and based on the reconciliation, you have information, key information about what? Key information about the status of your client. That will definitely help you. That will definitely help you in deciding on the next action that you should take in respect of the client. Okay, and what you can also consider to apply a threshold in terms of the investment pattern. Okay, because on the basis of the investment pattern of your client, you can decide, 10,000 was invested initially, so he has maturing investment, so he have had in terms of interest paid to him, okay, in terms of dividend or whatever, so he has received. So if he comes to invest now an additional 10,000, so you can tally the records. Okay, but if you can't tally the records, you ask the question. Okay, and by doing this, you avoid the case of going to the client here and there, and the client gets, you know, how it is. Okay. Any mismatch has to be investigated. So this is what we have as instances that require, that we have termed as red flags. Expectation, remember, expectation and actual. So there is a mismatch. So this require further inquiry, further assessment. Okay. And yes, I just talk about the omnibus account. So it's just the concept of regulated entities. Omnibus account you may have, because you know omnibus account operated by fund managers, investment managers, licensed in their respective jurisdiction. Okay, in their respective jurisdiction. So we need to, as we claim that we are licensed and regulated, they also licensed and regulated. So what do we do? The concept of reliance and trust. Okay, concept of reliance and trust. Eligible introducer. Okay, so what we recommend in respect to these cases, such cases. So firstly, we have to identify the service provider. We have to get the confirmation and proper confirmation that it is indeed licensed and regulated. What are the internal control that has been put in place at its end, and the basis to match whether it is corresponding to that of Mauritius. And in terms of the investors, here I'm proposing it to be like this, but it can differ. It can be different because it depends on the mandate. Because omnibus accounts can be operated by a portfolio manager that compiles all the funds and then for investment, or on specifically to the mandate, investing on behalf of someone. If it is on behalf of someone, so this is the question that you need to ask, and that service provider, what we expect from him for our compliance purpose, to have at least the names of those investors. Okay, so this is a test case. You know how things goes on, and omnibus is indeed a very topical issue. Okay, this has been part of different assessment in terms of investigation as well. Different closed-end funds, CIS, have been subject to inspections from the regulatory authority. And one of the deficient area. Okay, so this is what we propose. Build up your case, ask the question, get the information, and although we can't do otherwise, the concept of reliance and trust is convenient but dangerous. We acknowledge, but you need to present your case. Okay, instead of having nothing, at least you have something to show to the regulator. And as part of your client risk assessment, this is what you have done. Reasonable. Okay. And yes, I've gone through the slides with you, and as a summary, so this is what we have in terms of proposed solutions to have a realistic and practical business risk assessment. No one size fits all strategy. Does it work? Okay. Risk mitigating strategy, explore other sources of information. Just don't rely on documentation that you are expected to receive as per the law, as expected by the regulatory authority. Okay, explore. Okay. Relative to the nature and business industry, to evaluate your risk weightage. This is what I mean, what I meant before when I said in terms of the assessment factors, it will have to be adapted to your BRA, and your BRA adapted to your nature of activity. And I see that Umar is here, so I know that I have to close over here. So this
if we could just close in 1 minute, please, Keshal. Thank you.
Okay. So this is what we have for you. I have just gone through this when I was discussing the test cases. So this is what we have. Feel free to send us your questions if ever you need any clarification on this. And on this one, I want just to highlight that, to bear in mind that requesting for due diligence document or clarification in respect to a transaction is not tipping off. Okay, this is again another debate. But for compliance purposes, this is what I wanted to clarify over here. Document your case, present your case. And in what way? This is a template that we propose. Okay, this is what we propose. You have it here. You will have it for your reading, and our team from Arrowheads would be more than happy to help in case of any devising or putting into place such a risk mitigation strategy at your end. Okay. So this is what I have for you as a concluding remark. I think Umar will be taking over with a last slide, concluding remark, and this is what we have for you. And yes, thank you very much for your attention, and be practical, be pragmatic, and apply the concept of compliance analysis, build up your case, and by documenting your findings. This is what I can conclude on. Thank you very much for your attention, guys.
Thank you, Keshal. Unfortunately, because we don't have much time left, we won't be doing concluding remarks. But I think we've covered all the important subjects, and the audience has had a good grasp of every aspect of the identification of funds and social wealth. Now, that said, we won't have time for questions either. But as I said, and as Keshal just highlighted, please follow us on LinkedIn, and we will be posting regularly on the questions we received, either through the registration process or those we receive in the chat box. So especially on the crypto one, we have a series going on right now about crypto compliance awareness. So we'll be sharing about information about what it means to do source of funds for crypto specifically. And we're very sorry for spilling over a bit in terms of time, but I'm sure the audience found the content valuable, because I see that many participants are still here with us. I want to thank our three speakers for agreeing to take time off their busy schedules to share their experience with us. I really appreciated the fact that our speakers are very cognizant of the local context, and I think the audience felt that too. A big thank you to all our participants too. We will be posting the recording in a few days. As I said, it will be on our LinkedIn page, and we also intend to have similar webinars in the future. So if the audience or any professional in the sector feels that there's a specific topic they'd like to hear about, feel free to message us on LinkedIn, send us an email, anything. We'd be glad to see if we can be of help. So again, thank you everyone, and have a nice evening. Bye-bye.